Hello, and thanks for joining us today on USSC Live, the United States Sentencing Commission series of interactive webcasts produced in conjunction with the Administrative Office of the United States Courts and the Federal Judicial Center. In this edition of USSC Live, we will first discuss frequently asked questions about the retroactive application of Amendment 782, the Drugs Minus 2 Amendment that went into effect on November 1st, 2014. Second, we will highlight recent Commission data. And third, provide you with an update on recent Commission business and activities, including the proposed amendments that have been published for public comment. I'm Krista Rubin.
And I'm Rachel Pierce. As Krista stated, on today's program, we will cover some of the frequently asked questions that you have had about the retroactive application of Amendment 782, the Drugs Minus 2 Amendment. In our last program, we discussed how to apply this amendment. Since that time, we have received several questions about application issues that we would like to answer for you. As always, if you have any questions on any of our topics today, please submit your questions in the box below. Just scroll down on your screen and you will see the questions box, or you can email us at training@ussc.gov. We will post that email address throughout the program, and we will do our best to answer those questions as we receive them.
Thanks, Rachel. If you joined us on either of our last two webcasts, you are aware that we have been discussing one of the recent amendments promulgated by the Commission, Amendment 782, the Drugs Minus 2 Amendment, and the retroactive application of that amendment. Since our most recent webcast in October, which you can find on the Commission's website, we have received several questions about the retroactive application of the Drugs Minus 2 Amendment that we would like to answer for you today. But before we get to those questions, Rachel, can you briefly describe the amendment for us?
Sure, Krista. The Drugs Minus 2 Amendment, Amendment 782, reduces by 2 levels the base offense levels applicable to most quantities on the drug quantity table at the drug guideline, 2D1.1, and on the chemical quantity table at the listed chemicals guideline, 2D1.11. These changes to the tables at 2D1.1 and 2D1.11 are prospective, meaning that any defendant sentenced in federal court on or after November 1st, 2014 for a drug trafficking or listed chemical offense will have their guidelines calculated using these new lower drug and chemical quantity tables. In addition, this amendment was also made retroactive by the Commission, meaning that this amendment can be applied to some drug offenders who were sentenced prior to November 1st, 2014, and who are currently serving a term of imprisonment. Guideline 1B1.10 is the guideline that addresses the retroactive amendment. The Commission added a special instruction to Guideline 1B1.10, which states, "The court shall not order a reduced term of imprisonment based on Amendment 782, the Drugs Minus 2 Amendment, unless the effective date of the court's order is November 1st, 2015 or later."
Thank you, Rachel. Before we address the first question, let's review the form that all courts must fill out as they process the Amendment 782 cases. AO Form 247, which you can see now on your screen, was developed specifically for courts to use when addressing retroactive guideline amendments. The Commission asks that copies of all orders in these cases are sent to the Commission regardless of whether the motion for a reduced sentence was granted or denied, and regardless of whether the offender was found to be eligible to seek a reduction under the Drugs Minus 2 Amendment.
That's right, Krista. It's very important for courts to submit the AO Form 247 so that the Commission can collect and share accurate data about this retroactive drug amendment. We have, however, been receiving questions about the form itself.
Right, and one such question refers to the section of the form you see here on your screen. Users have asked us to clarify the appropriate dates to be recorded on the form. We will clarify the meaning of order date and the effective date. First, the order date is the date that the court issues the order on the defendant's motion for a reduction in sentence. The effective date is different from the order date. The effective date is the date that the court wants the order to go into effect. As we just mentioned, the Commission amended 1B1.10 to state that the effective date for any order granting a motion for a reduced sentence based upon the drugs minus 2 amendment must be November 1st, 2015 or later, even though courts have been issuing these motions since November 1st of 2014. The Commission provided this effective date of November 1st, 2015 to provide the Bureau of Prisons with a sufficient amount of time to provide the maximum transitional services available for the defendants who are granted a reduction in their sentence. The BOP needs approximately 9 to 10 months to provide these transitional services. Please note that the court need not calculate the release date for each defendant in order to provide the effective date for this form. The Commission sent all districts a list of defendants potentially eligible for a reduction under the drugs minus 2 amendment, and the list contained the anticipated release date for each defendant. This list is intended to assist the districts in prioritizing which motions to address first.
That's right. Now, Krista, some people have inquired about the meaning of effective date. They've expressed concern that without the official release date for each defendant, the Bureau of Prisons will not know when to release the offender to a halfway house in advance of their release date if the effective date is November 1st, 2015. The Commission has kept in close contact with the Bureau of Prisons through the Department of Justice, and the Bureau of Prisons is aware of the specific criteria surrounding the retroactive application of this amendment. Courts should continue to prioritize orders for those defendants facing release soon, and the BOP will handle halfway house assignment as it is able.
Thanks, Rachel. Now, we have also received several questions regarding drug defendants who were originally sentenced on multiple counts of conviction and how those additional counts of conviction impact the defendant's eligibility for a reduction in sentence based upon Amendment 782. So, for example, a defendant was sentenced on 2 counts, drug trafficking under 2D1.1 and felon in possession of a firearm under 2K2.1. The question is, will the offense level for the felon in possession count impact the extent of the reduction?
Well, Krista, it depends on the specific offense level calculations for each count. For example, if at the original sentencing, the offense level for the felon in possession count was 28, and the offense level for the drug trafficking count was 24, then the defendant would not receive a benefit of a sentence reduction because, after grouping the counts, the offense level 28 for the felon in possession determined the guideline range for the 2 counts of conviction. Meaning that even though the drug count may be reduced to an offense level of 22, the counts would still group together and the combined offense level would remain 28 based on the higher offense level of that felon in possession count of conviction. Therefore, the guideline range applicable to this defendant has not been lowered as required under 1B1.10. In contrast, however, if at the original sentencing the offense level for the drug trafficking count was 28 and the offense level for the felon in possession was 22, then the combined adjusted offense level after grouping the 2 counts is based on the higher offense level of the drug trafficking count of conviction. The defendant in this case would be eligible for a sentence reduction because after grouping the counts, the offense level of 26 for the drugs, which is 2 levels less because of Amendment 782, and the 22 for the felon in possession, the drug trafficking count controls.
And here's a third example, Rachel, that's a bit more complicated. At the original sentencing, the offense level for the drug count was 28, and the offense level for the felon in possession was 27. After application of the drugs minus 2 amendment, the drug offense level is 26 and the felon in possession offense level remains at 27. So in this case, the extent of the reduction would be limited to 1 offense level 27, because the felon in possession count would now control the combined adjusted offense level for the group of multiple counts. So the defendant's offense level would not be reduced to 26 in this case. Now, Rachel, we've also had questions from guideline users about the situation when at the time of the original sentencing, the court did not make a specific finding about drug quantity. So let's talk a bit about what to do in that situation.
Sure. Let me give an example. The court at the original sentencing held the defendant accountable, let's say, for more than 15 kilos of methamphetamine, which at the time of the original sentence was at the top of the drug quantity table, level 38. As a result of the drugs -2 amendment, the drug quantity table at level 38 for methamphetamine changed to 45 kilos or more of meth. Additionally, level 36 of the drug quantity table for methamphetamine changed to at least 15 kilos but less than 45 kilos of meth. In considering a retroactive reduction under the drugs -2 amendment in a situation as I just described, some guideline users have asked how to determine if the defendant is eligible for a reduction from the original offense level of 38 to the amended offense level of 36, when the court found that the defendant was accountable for more than 15 kilos of meth. So the specific question is, can the court at a 3582C2 proceeding make a more specific finding of the drug quantity to determine if the defendant is eligible for a reduction? Because in this example, if the specific quantity is less than 45 kilos of meth, but greater than 15 kilos, the defendant may be eligible for a reduction to an offense level of 36 pursuant to that amended drug quantity table.
Well, Rachel, there are a number of circuit decisions that permit the court to calculate a specific drug quantity when considering a motion under 18 U.S.C. 3582C2. And these decisions rely on the original sentencing court's adoption of the pre-sentence report and hold that the court, upon consideration of the 3582C2 motion, can look to the PSR to determine a more specific quantity attributable to a particular defendant. And these cases are U.S. v. Hernandez from the Fifth Circuit, U.S. v. Moore from the Sixth, U.S. v. Woods from the Seventh Circuit, another case called U.S. v. Moore from the Eighth Circuit, and U.S. v. Battle, which is from the 10th Circuit. So if you have this issue arise in your district, please look to these cases for additional information. And you know, Rachel, another question we've received is whether a defendant who is not convicted of drug trafficking, but whose guideline calculation is based upon the calculation of the drug guideline 2D1.1, whether that defendant is eligible to seek a reduction in sentence under 1B1.10. So what can we tell our viewers about this situation?
Well, Krista, let's take an example of a defendant who was convicted of one count of money laundering. The applicable guideline is 2S1.1. In the calculation of the base offense level at 2S1.1A1, that directs the court to apply the offense level for the underlying offense. So in a case in which the court looked to the drug guideline at 2D1.1 to calculate the base offense level for a defendant convicted of money laundering, that defendant would be eligible to seek a reduction in sentence under 3582C2 and 1B1.10. 1B1.10 requires that the guideline range applicable to a defendant has been lowered as a result of an amendment listed in that guideline. So in this example, the defendant's guideline range would have been lowered by 2 levels based upon Amendment 782 because his guideline range was established using the drug guideline, even though that defendant was not convicted of a drug trafficking crime. As always, if you have other questions that we have not addressed today, please do not hesitate to send them to us. Again, our email address is training@ussc.gov. Now, let's turn our attention to some of the most recent Commission data that our Office of Research and Data has published through the Quick Facts series.
We first told you about the Commission's Quick Facts series on our USSC live webcast back in March of 2014. At that time, there were 10 Quick Facts publications, and now there are 17 Quick Facts publications. 7 on drug trafficking crimes, 1 on economic crimes, 2 on firearms offenses, 2 on immigration offenses, 1 on mandatory minimums, 1 on national defense, and 3 on offender groups, career offenders, Native Americans, and women in the federal offender population. We will start our discussion of recent Commission data by looking at the quick facts on offender groups, starting with the women in the federal offender population. You know, one of the interesting facts contained in this publication is that female offenders are convicted of a statute carrying a mandatory minimum penalty at a lower rate than male offenders.
That's right, Krista. In fiscal year 2013, in fact, 24% of female offenders were convicted of a mandatory minimum penalty versus 26.9% of male offenders. And out of the approximately 80,000 federal cases in fiscal year 2013, only 9,500 involved female offenders, which equates to 13.3% of all federal offenders.
And that number is, is that number consistent across fiscal years, Rachel?
Well, while women represent a small percentage of federal offenders, that number is actually up slightly since 2009 when it was 12.1%.
Let's talk about the types of offenses female offenders are convicted of. What are the most common offenses committed by females in the federal system?
Well, the most common offenses committed by female offenders are drug trafficking at 33.7%. Fraud comes in behind that at 23.9%, and then followed by immigration offenses at 14.3%.
And what else do we learn about female offenders in this new Quick Facts publication?
Well, demographically, we learn that the average age of female offenders in the federal system at sentencing is 38, and the majority of them are United States citizens. Regarding sentencing practices, female offenders are sentenced to imprisonment at a lower rate than their male counterparts for each of the most common offense types. For example, 90.3% of female drug trafficking offenders received a sentence of imprisonment, whereas 97.3% of male drug trafficking offenders were sentenced to imprisonment in fiscal year 2013. This new Quick Facts also tells us that for each of the past 5 years, female offenders were sentenced within the guideline range in less than half of all cases.
Interesting. Let's move on to the next Quick Facts publication addressing offender types.
Sure. Let's talk about the career offender Quick Facts. But first, let me remind our viewers who qualifies as a career offender. The Career Offender Guideline, 4B1.1, was written in response to a directive contained in the Commission's organic statute at 28 USC 994H. This statute mandates that the Commission assure that certain career offenders receive a sentence of imprisonment at or near the statutory maximum authorized. Career offenders are defined as individuals who are at least 18 years of age and have been convicted of a crime of violence or a drug trafficking crime after 2 prior felony convictions for a crime of violence or a drug trafficking offense. Under the guidelines, all career offenders are assigned to a criminal history category 6, which is the highest criminal history category, and their offense level will be increased based on the statutory maximum penalty for the instant offense of conviction.
Now, Rachel, this particular Quick Facts on career offenders is directly related to one of the Commission's priorities this year, a continuation of its multi-year study of statutory and guideline definitions relating to the nature of a defendant's prior conviction, which of course includes a look at the terms crime of violence and drug trafficking offense, 2 big considerations under this guideline.
Krista, what does the Quick Facts on career offender tell us about the demographics of these individuals?
Well, Rachel, the overwhelming number of career offenders are male, which is not surprising given the percentage of female offenders in the federal system. The average age of defendants sentenced as a career offender is 37, and nearly all career offenders were United States citizens, approximately 97%.
We discussed the increased penalties for career offenders as we started this segment, increased offense levels and an increased criminal history category of 6. What is the average sentence for defendants who qualify as career offenders?
Well, the average sentence imposed on career offenders is 160 months. Interestingly, almost 2/3 of these offenders would have had a criminal history category lower than 6 if the career offender provision had not applied. So also, the rate of within-range sentences for career offenders has decreased over the last 5 years. The rate of below-range sentences, both government-sponsored and non-government-sponsored, has increased over the last 5 years.
Now, given the parameters of how a defendant qualifies as a career offender, can you tell us the breakdown of defendants who were convicted of a drug trafficking crime versus those who were convicted of a crime of violence?
Yes, absolutely. 3/4 of career offenders had an instant offense of conviction for drug trafficking, followed by robbery, which was at 11.5%, and then firearms offenses at 5.1%.
Thanks, Krista. Let's now talk about our last offender group in the Quick Facts series, Native Americans. Native American offenders account for a small but increasing portion of federal offenders.
That's right, Rachel. And this publication is related to a recent package of amendments to the guidelines effective November 1st of 2014, which responded to the Violence Against Women Reauthorization Act. This act provided new and expanded criminal offenses and increased penalties for certain crimes pertaining to domestic violence, assault, sexual abuse, stalking, and human trafficking. Also, as part of this legislation, tribal jurisdiction over non-Native Americans who commit crimes of domestic violence or sexual assault against a Native American spouse or partner was expanded. Now, the Commission amended several guidelines in response to this legislation.
Also related, Krista, is the creation of the Tribal Issues Advisory Group, an ad hoc advisory group to the Commission. This group will provide the Commission with its views on federal sentencing issues relating to American Indian defendants and victims and to offenses committed in Indian country. The membership of this advisory group includes federal judges, representatives from the executive branch, and the federal defender community. The members of the Tribal Issues Advisory Group have membership in or experience with tribal communities, or have expertise in Indian law and federal criminal law, or American Indian crime victimization issues. The Commission will announce the members of this advisory group in the near future. So, this publication is very much related to recent Commission business. Let's talk about some of the information we learned from this quick facts publication. First, where are the majority of Native American offenders sentenced in the federal system? And what are the most common offenses committed by Native American offenders?
Well, the top 5 districts for cases involving Native American offenders are South Dakota, Arizona, Montana, New Mexico, and North Dakota. Now, the most common offenses committed by Native American offenders are drug trafficking, aggravated assault, fraud, and firearms. And additionally, almost half of Native American offenders had little or no prior criminal history.
That's interesting. Krista, what can you tell us about the sentencing of Native American offenders?
Well, Rachel, the majority of Native American offenders were sentenced to imprisonment, and the average sentence imposed on Native American offenders has remained relatively constant over the last 5 years, although it is lower than for U.S. citizen offenders generally. Now, the average sentence imposed on Native Americans last year was 49 months, while the average sentence for all U.S. citizens was almost 25% higher at 61 months. Also, interestingly, Native American offenders were sentenced within the guideline range more than half of the time.
That's a great overview of the information from that publication. Thank you, Krista. Please remember that in addition to the 3 quick facts we have highlighted today, there are several other recently updated quick facts that provide interesting data on offense types, including drugs, immigration, firearms, and economic crimes. Those publications can be found on our website, of course, as well as other recent publications from our Office of Research and Data. Krista, why don't you tell us about it?
Absolutely. The Office of Research and Data published in August of 2014 the fiscal year 2013 overview of federal criminal cases. Now, this publication takes a look at the big picture of federal cases in fiscal year 2013. Viewers will find information on the most common crimes in the federal system, the type and length of punishments imposed for those crimes, as well as the offender characteristics of the people committing those crimes. The report also provides information on resentencings and other sentence modifications.
Thanks, Krista. Now we will turn our attention to an update on the most recent Commission business. The Commission continues to work on its 2014-2015 policy priorities, and on January 9, 2015, the Commission voted to publish in the Federal Register for public comment amendment language addressing those priorities. The Commission is seeking comment on the proposed amendments. The proposed guideline amendments address issues such as economic crimes, drug offenses involving hydrocodone, mitigating role, single sentences under the criminal history guideline, jointly undertaking criminal activity under the relevant conduct guideline, and inflationary adjustments. Krista, let's talk a little bit about these proposed amendments.
Sure. Well, the first proposed amendment published for comment addresses several issues related to economic crimes offenses. First, the proposed amendment provides options to revise the definition of intended loss at the fraud guideline, 2B1.1, to address concern regarding the operation of this principle and suggestions that the Commission consider certain revisions to better reflect a defendant's culpability. Second, the proposed amendment addresses issues related to the impact of the victims table at the fraud guideline. Now, specifically, the interaction between the number of victims and whether those victims suffered substantial financial hardship. And so 2 options are provided there. Now, third, the proposed amendment addresses the application of the sophisticated means enhancement at 2B1.1. This part of the proposed amendment considers whether the enhancement should be revised such that it applies based only on the defendant's conduct rather than the offense as a whole, and whether the conduct should be compared to similar frauds or to all frauds under 2B1.1. And the final part of this proposed amendment provides language to address fraud on the market and related offenses. Now, this all resulted from the Commission's continued work on economic crimes and involves the Commission's past work in implementing the directive in the Dodd-Frank Wall Street Reform and Consumer Protection Act.
The quick facts publication on economic crimes would be helpful in thinking about the proposed amendments in this area. The Commission welcomes and encourages comments on this and all the proposed amendments. So moving on, there is also a proposed amendment addressing drug offenses involving hydrocodone. All hydrocodone products are now classified as Schedule II controlled substances rather than Schedule III controlled substances. The proposed amendment addresses the resulting new statutory penalty structure. And although we do not have a quick facts on hydrocodone, we do have one on oxycodone, which is a similar substance, and so it may be helpful to persons who would like to comment on this proposed amendment.
And also regarding drug offenses, the Commission has published an issue for comment on flavored drugs. These are controlled substances that are colored, packaged, or flavored in ways that appear to be designed to attract use by children. The issue for comment is seeking input on whether the guidelines adequately address this particular conduct. Now, Rachel, what about the proposed amendment on mitigating role?
Well, Krista, the proposed amendment addresses the term average participant as found in the mitigating role guideline at 3B1.2. There are differences among the circuits as to the requirements for determining what an average participant is. So the proposed amendment also includes factors for the court to consider in applying this adjustment in a particular case. Also published for comment in the Federal Register is a proposed amendment that is a result of the Commission's effort to simplify the operation of the guidelines, including, among other matters, the use of relevant conduct involving multiple participants. There's also a proposed amendment addressing a circuit conflict regarding the meaning of the single sentence rule in the criminal history guidelines and its implications for the career offender guideline and other guidelines that use predicate offenses. When the defendant's criminal history includes 2 or more prior sentences that meet certain criteria specified in 4A1.2A2, those prior sentences are counted as a single sentence rather than separately. This operates to reduce the cumulative impact of the prior sentences on the criminal history score. So courts are divided over whether this single sentence rule also causes certain prior sentences that would ordinarily qualify as predicates under the career offender guideline to be disqualified for serving as predicates. Krista, in addition to some technical amendments, there is one other proposed amendment published for comment that we would like to mention.
Sure, that's right. And this proposed amendment for comment addresses inflationary adjustments. And this amendment resulted from the Commission's work in examining the overall structure of the guidelines post-Booker. The proposed amendment illustrates a possible approach for implementing an inflation adjustment during this amendment cycle to the monetary tables in several guidelines, including robbery, burglary, bid rigging, and fraud. And, Congress has generally mandated that agencies in the executive branch must, every 4 years, adjust the civil monetary penalties they impose to account for inflation. Although the work of the Commission does not involve civil monetary penalties, the monetary values in the Chapter 2 offense guidelines have never been revised to specifically account for inflation. The deadline for receiving public comment is no later than March 18th of 2015. Before we wrap up today's program, related to the Drugs Minus 2 amendment we discussed earlier. Judge Patty Saris, chair of the Sentencing Commission, who has previously joined us here on USSC Live, has published an article titled "A Generational Shift for Federal Drug Sentences." This article is based on a speech given by Judge Saris at Georgetown University Law Center on March 26, 2014. The article can be found on our website at ussc.gov. Well, that's all the time we have for today. We spent the first part of our program discussing questions that we've received about Amendment 782, the Drugs Minus 2 amendment.
That's right. We then discussed some of the most recent data that has been published by the Commission's Office of Research and Data to include quick facts on women in the federal system, career offenders, and Native American offenders. We then wrapped things up with highlights of the proposed amendments for public comment and a brief discussion of some recent Commission business.
Thank you for joining us. Please take a moment and give us some feedback on this webcast. Also, don't forget to let us know if you have any suggestions for future webcast topics. We'll see you next time on USSC Live.